Hi, my name is Tim Pearson, and I will be playing the role of one of the jurors in this case. The plaintiff, Jennifer, was recently in a car accident and is now recovering at home from a 5-day hospital stay. The other party's insurance company is refusing to take care of her medical bills. Now that Jennifer has contacted an attorney, she has concerns that her privacy has been violated under the law. The defendant, Ashford Hospital, however, has a different perspective. They state that they did operate within the parameters of the law and therefore are not liable in this case. The bottom line question is this: did the hospital have the right to disclose protected health information to the insurance company? Now for me, I've recently experienced this exact situation just a few months back. My daughter was in a car accident at the beginning of March, and she was in the hospital for a few weeks. We received contact and communication with the insurance company asking for release of health information. Therefore, I'm somewhat familiar with how the law works on this point. However, I won't use that experience to base my decision, but rather just have it as a point of reference. The disagreement within this case is focused around two key issues. First, everyone agrees that the subpoena was issued without a court order. No one disagrees on that point. The disagreement, however, is whether or not the court order would have been required in this situation. And the second area is that everyone agrees that the hospital did not make any efforts to contact the patient to get her authorization. The hospital doesn't deny that. However, the disagreement here is whether the hospital was required to make that effort. Now, as a consumer and as a person with no legalized contract reading training of any sorts, this document, the HIPAA privacy law, is certainly absurdly long in length and breadth. For the average person to be able to read and decipher all that it holds is a preposterous notion. However, it is what it is. This is the law, and this is the law that the plaintiff has suggested that the hospital has violated. So what the law says is what I will use specifically to reference when I'm casting my vote. The specific section of the law that pertains to this case was identified as Section 164512 of the HIPAA privacy law. Now this part of the law describes situations in which health information may be released with a subpoena not being accompanied by a court order. The law describes what types of situations are, what these types of situations are, and the law reads exactly like this. Quote, in response to a subpoena that is not accompanied by an order of a court or administrative tribunal, if, end quote, and then after the if, there are a series of kind of a laundry list, if you will, of situations where the court order would not be needed. One of those situations is that if there has been a reasonable assurance that there was effort to contact the patient by the company seeking the information. So in this case, if there was an assurance to the hospital that the insurance company had made effort to contact the plaintiff, then they would not be required to reach out to her. Now the plaintiff has made the argument that the hospital violated the law by releasing the information through a subpoena that was not accompanied by a court order. After comprehending the wording of this law, I'm convinced that this is not a valid argument. Now on the second point regarding whether or not the hospital was required to make contact, just like I previously mentioned, this law does provide an out in this situation. The hospital is not required to make contact if they've received this reasonable assurance that the requesting company has made those attempts. Now the law, however, does read that the hospital couldn't have just had the insurance company tell them, but they actually had to have written statements and documentation, and that must be provided to them to meet this requirement. And the hospital was in fact provided with proof that a request had been sent to the plaintiff's address, and therefore that satisfied the requirement needed. Now the plaintiff has made it clear that she was not contacted by the hospital. but has not commented about any contact from the insurance company regarding this matter. She was very specific on this point. In fact, in her testimony, she said that she received no contact from anyone from the hospital, with no mention of any contact from the insurance company. So the plaintiff's argument is that the hospital was required to contact them, and because they didn't, they violated their law. Again, we see this is not accurate. So to conclude my thoughts, my opinion is that the moral thing for the hospital to have done, and mind you, I said the moral thing for them to have done, would have been to make contact with the plaintiff, otherwise known as their patient. I mean, she had been under their care for a number of days. They were providing this care for her. She was being a source of revenue for their business model. You know, she had a bill that she had accumulated with them. So they probably should have taken care to make sure that she had, in fact, um, wanted this information released. However, with that said, the law reads that they may do that if they choose to. However, I mean, I can see their perspective, and they have a legal obligation to the insurance company as well as to follow the law. If they had made the efforts to contact her and delayed the process, perhaps we might be hearing a case today between the insurance company and the hospital instead. Overall, I find that the plaintiff's arguments are unsubstantiated, and therefore the hospital did not violate the law. Therefore, I vote in favor of the defendant. Thank you.